If you want to get a divorce, all you have to say or believe is that the marriage has irretrievably broken down.
But are there any circumstances in which that adultery would be taken into account within the divorce proceedings or the finances or the children proceedings? I've only ever had one case where conduct has really made an impact on the financial settlement. And when I speak to clients, I always explain it has to have the gasp factor. It has that.
I gasped.
It has that gasp factor.
So what is better, to stick them to the post or whatever you want to do, is to run a really strong case otherwise.
Welcome to Life, Love and the Law, a podcast by Stowe Family Law. My name is Liza Gatrell, and today I am joined by Emily Beven, who is a senior associate in our Reading team. So welcome to the podcast, Emily.
Thank you very much. Happy to be here.
Lovely to have you. So we have got the topic today of, can adultery affect divorce in the UK? Mm-hmm. Can you tell us a little bit about the changes in the law and the reasons for divorce that have happened over the last few years?
Yeah, so I always say fairly recently we had a big change in the law, but actually it's not fairly recently. This has been quite some time in the making. And we've moved away from a system where you had to place blame, a blame-based system where you could apply for divorce based on only a few different criteria in terms of, it used to include adultery, for instance, or desertion or 2-year separation. Now, all of that criteria has fallen away and we are in a blameless system where essentially, if you want to get a divorce, all you have to say or believe is that the marriage has irretrievably broken down and you're unable to source any other reason why. Now, that comes as quite a disappointment to some clients who feel like they've been really wronged. But unfortunately, the system just doesn't provide for an outlet for you to say the reason why you're applying for that divorce or come to the decision that the marriage has broken down ultimately.
I mean, it can be really upsetting, can't it, for a party if their ex-spouse has committed adultery, that they are the reason why the marriage has broken down, that effectively, you know, your life is now being thrown up in the air and you're having to go through all of these proceedings that you didn't think you would have to. And you're very much kind of putting the blame in their court. Is the adultery is not taken into account in relation to the divorce itself? But are there any circumstances in which that adultery would be taken into account within the divorce proceedings or the finances or the children proceedings?
Yeah. So a lot of people listening will be in the process of going through their Form E and the financial side of things. And within the Form E, it's sort of like a red herring box that you get to tick that says, do you want to consider conduct in the premise of these proceedings? And a lot of people will send back their drafts in the first instance with a full box with an exhibited page outlining all of the conduct that they feel should be relevant to the settlement at the end of the day. And while some of those concerns are entirely valid, and you can see why clients want to be heard about those criticisms, they're very rarely taken into account within financial matters. There are certain circumstances where they will be, if that conduct, behavior, has a material impact on the outcome. So in circumstances where, let's say someone has a really bad gambling problem, sometimes that's going to be taken into account if it's seen to have dissipated the assets. But even so, it has to be seen as severe enough to be taken into account. So generally speaking, conduct arguments are not really going to be worth pursuing. And adultery specifically is almost never going to be relevant to the outcome of financial settlement. And that is really disappointing for some clients.
Yeah,
rightly so.
And running these types of conduct arguments, it can also add significantly to the cost of the proceedings because we have to have additional statements.
Yeah.
And we have to have evidence heard at the final hearing.
Yeah.
It really complicates things as well. I've only ever had one case where conduct has really made an impact on the financial settlement. And when I speak to clients, I always explain it has to have the gasp factor. I had a case where the husband had gone out, he'd gotten really drunk. He happened to be my client. He'd gone out, he'd got really drunk. And as he had been walking home, he had seen his ex-wife and he had made some really serious threats to harm her on his way home. Had gone back to the matrimonial home where they'd been living together and had put all of her clothes in his drunken state into the bathtub and set fire to them. In his drunken state, thinking just the clothes will go up, but half the house went up in this house fire. And so naturally, the judge within the financial settlement, because obviously now we've impacted the value of the family home and all of those types of things, said that he should absolutely be penalised for his conduct in dealing with that. But it has that
I gasped.
It has that gasp factor, so it's taken into account. But it can be really challenging when you're really hurt by somebody's behaviour and you feel like there should be some sort of reflection of that.
Yeah.
They should be punished to a certain extent
Absolutely.
for the way they've hurt you within the proceedings. But it's just really it's just not considered.
Right. But I think ultimately, and I try to frame this for clients that are kind of going down this road and hesitant to let go of the resentment that they're feeling, that ultimately if we're proceeding with a weak conduct argument and you're spending a lot of money trying to fight that corner, and we know that's probably not going to be a successful argument, you're ultimately just diluting what you're going to get in the end. So what is better, to stick them to the post or whatever you want to do, is to run a really strong case otherwise and get you out of the relationship with more so that you can have a happier future without them. Let's stop raising tensions. Let's come to an agreement. Let's not waste time. Let's come to an agreement as soon as possible, and one that is going to allow you more resources than if you'd wasted 20, 50 grand fighting a losing battle in terms of a conduct argument. That being the case, obviously there's situations where it's going to be relevant like that. I mean, I've never had a case like that. I have had cases where dissipation has come into play, where it became clear through the voluntary exchange process that someone was siphoning funds abroad in a deliberate attempt to hide money. That then did lead to a successful add-back argument. But that argument and tracing the funds and all of the hearings that ensued cost a lot of money. And it was a long process as it extended it. And who knows whether or not in proceeding with that, we got a better result than what we would have done otherwise, given that the resources were diluted throughout that process. So I guess what we're saying is that this is an area where you need to get specialist advice at an early stage to give you some honest advice about whether or not your feeling of being neglected or treated in a certain manner should be taken into account, or whether or not we should focus more on outcome.
No, that's really good advice. And I was just thinking, like, other areas in which adultery can impact within divorce proceedings is new partners. So particularly, let's say, ex-partner has committed adultery. They are now in a relationship with this new person. Couple of questions comes out of that. First of all, what happens if they move in with that new person? Is there any implications of that within the divorce process?
Yeah, well, it's a really common question. I'm sure you get it a lot as well. And again, heightens the tension even further when this person has then moved in with that other individual. Obviously, that's going to be really hurtful and leads to a reaction. And this is something that could potentially impact the outcome. If your partner or your ex-partner moves in with their new partner during the course of financial proceedings, it's possible that the resources of the partner should be taken into account as being a resource also available to your ex-partner. So for instance, when we're talking about this concept of needs and housing needs in particular, if both the new partner and your ex-partner are working, surely both of their incomes will be taken into account when it comes to mortgage capacity. That's something that we could argue should be taken into account. Now, in reality, sometimes these arguments are not very successful because people will beat around the bush about how serious their new relationship is, or will say that it's temporary that they're living with them because they're waiting for the outcome of financial remedy proceedings. And ultimately, if that's what someone's hanging their hat on, whether they're being dishonest or not, that's what they're saying. And we can't compel someone to provide information about their partner unless we know that they do hold that information. So it is a difficult one. It's a bit of a minefield. It can be disappointing. It can lead to high emotions. And whilst I think it should be taken into account and perhaps argued during the course of negotiations, it might not be something that a judge is going to be super fixated on when looking at outcome.
Yeah. And coming from that then, if you've got children involved, so ex-partner has moved in with new partner and we're looking at child arrangements, a question that's often asked is, can I stop the new partner from seeing the children?
Yeah, and it's an interesting one. I think unless you have really important and serious safeguarding concerns about that partner, then there's no reason to withhold access. I mean, in an ideal world, and we see this all the time, couples would come together post-separation and agree how a new partner is to be introduced or what the process is before the children is to meet them. But an individual's time with their children is an individual's time with their children. And unless it's raised in the context of safeguarding or welfare issues, a judge is likely going to look at it and say, well, you're allowed to spend your time as you wish, which can also heighten tensions, because I could fully appreciate not wanting your kids to be around someone if you perhaps blame them for breaking down your family. Mm-hmm. That can be very hurtful, but there's very little we can do unless we have real genuine concerns about what they're being exposed to while in their care.
We like to round off the podcast episodes with a top tip. So if somebody that's listening to this now is going through divorce proceedings or children's proceedings and there has been adultery involved in that, what would your advice to them be?
So I think first of all, it's to acknowledge that's really difficult. And by no means would we ever wish to push your feelings about it to the side. I would say go get some really good legal advice, and a really good legal advisor, if they see you struggling with something like that, is going to point you in the right direction for additional support. We have divorce coaches or perhaps counseling, and those are better forums for you to sort of vent about those issues. What we need to do in the legal context is sort of put it to one side. And I always say to my clients, one step at a time, we're working towards bringing this to an end. Every step brings us a bit closer, and we need to take it step by step, simplify things, and get you to the end of the day. And that should be the main focus, is seeing the light through the trees and getting to the other side.
Brilliant. Thank you, Emily.
No worries.